case to come before the court today is Kyle Robson. This is Discount Drug Mart. Discount Drug Mart is the appellant here. You both have 15 minutes to present your arguments. Appellant may reserve up to 5 minutes for rebuttal. When you take the podium before you begin your argument, just let me know how much time you want to reserve. I'll do my very best to keep you apprised. Sometimes I'm good at it, sometimes not. I don't think this is any issue. I need to warn you about using victims' names or children, so we can move past that. We have read your briefs. We're ready to begin when you are. Okay.
Good morning. May it please the court, my name is Tim Johnson. I represent Discount Drug Mart, who is the appellant in this case and was the defendant in the underlying case.
Mr. Johnson, before you get into it,
both
counsel, I'm really interested in the final appealable, whether or not this is a final appealable order. I don't know if you plan on arguing it or not, but I would like to hear something about it as well.
I didn't get a chance to reserve my 5 minutes. Okay.
Is it 5? You want to reserve 5?
Okay,
I was going to ask you, believe me. And I'm starting your time now.
Okay.
Good.
Maybe we won't need it. Yes, I didn't actually come prepared to argue that. I thought we were past that issue, but I am familiar with the issue, and it was fully briefed. And this is a declaratory judgment. There are other, there's no question the case was not fully resolved. There are other issues that were reserved by agreement of the parties and the court, and we tried just the declaratory judgment because it made a lot of financial and efficiency, economy type of considerations there. And so we all decided to do that, and I do believe that a declaratory judgment, which fully declares the rights of the parties on that particular issue that they went forward on, I believe that is, an exception to the normal rules regarding final appealable orders, that they be a final order.
Counsel, I agree. I guess I have a question, and I really apologize because I meant to take a copy of the complaint, or it was the amended complaint with me. As to that count, the count we're talking about with the declaratory judgment, was there also, I thought I recalled there was a request about a declaration about dividends also. I could be wrong, but I thought that was there. If so, did the trial court address dividends at all?
Yeah, I have a copy of the complaint if you want it, but that was reserved. That was an issue that was going to be reserved for the second part of the case once we made a determination as to whether or not Mr. Robson was in fact a shareholder, or whether the share certificates that he held were in fact valid, to be more correct. And all of those issues still need to be resolved once, possibly, depending on how this issue is resolved. Did I address it sufficiently for you? I do think it falls under the exception of a declaratory judgment being a special, I think the wording is special proceeding, and as I recall it. And I think, quite simply put, that's our position.
Well, I wanted to hear from you because I thought our order said we're going to schedule this for argument, but the finality is still an issue. But that's fine. Why don't you move on?
I will. I'd like to get to the meat of the matter at this point. And I want to, there's a lot here, but I hope I can boil it all down here. There has been a lot made of the presumption of the regularity or the validity of the stock certificates held by Mr. Robson. He had 2 stock certificates that were issued to him back in the early 1980s. He left his employment at Discount Drug Mart in 1984, It's our position, which is seen to be a little muddled in the briefs, that we paid him for those certificates. There's a lot of argument in the briefs about the redemption agreement, the stock redemption agreement, and all of that. But and whether or not it's really, all of that is really irrelevant, because whether or not he voluntarily gave them to us or he was required to give them to us, which we think is in fact the case. There was testimony, by the way, that by Mr. McConnell, who was, I guess, the oldest living person with knowledge of this. I mean, this happened a long time ago, you have to understand, and I know you can do math, but we're talking 30, 35 years ago, and as I look at all this equipment, PCs were just coming out in the early 1980s. So this was at the changing time, just to give you some reference in time, and I don't know, maybe some of you weren't even born yet, but it's a long time ago.
Flattery will get you nowhere. That's right.
Better to err on that side than
You're
the other,
absolutely
Your
right.
Honor.
You're absolutely
I've
right.
learned that much over the years. So, but getting back on track, what happened then, so he has these certificates. There was testimony explaining how he could still have these certificates. No one knows for sure, but quite regularly at the company, Mr. McConnell said, when it's time for an employee is leaving for whatever reason, and they have to sell their stock back to the company, and I'll get to that in a second, they allow that, if they can't find their certificates, which he indicated happens fairly regularly, because it sometimes involves a lot of time, that they allow the individual to execute a lost certificate affidavit, and they will take that in lieu of the certificates. Now,
Were those executed in this case?
well, we do not know. Well, here's what happened, is we were able to present the corporate records. First, obviously, Mr. Robson presented the certificates roughly 30 years after he left his employment at Discount Drug Mart. And we did present, and it was admitted into evidence, a number of documents that I could go through if there are specific questions that showed that he was no longer listed as and has not been for many years, listed as a shareholder. And that, of course, with the amount of time that transpired, we had limited records. And it's really, a lot of it is due to the time. And, but we did have a record that Mr. McConnell testified to. He was a CFO for 30-something years. And he was the main witness at the hearing on this. And he testified, this is from Arthur Anderson, the accounting firm that was their auditor at the time. There was a worksheet, and this is key to this whole case. It's Exhibit G. And this worksheet is a record that we got out of our business records, albeit there wasn't really anything else, and I'm going to touch on that in a second. This record shows, and I don't know if you may not have all the exhibits in front of you, but this is the key to the whole case. This exhibit shows that $8,170 was paid to Mr. Robson on 3/31/85. That is the exact amount of what the shares that he had 250 shares at $32.86. That's exactly what they were worth. His name is there. It's listed under stock redemption. And the math works out. We spent a bunch of time at the hearing, and that is, I think that's Exhibit H, and basically shows 250 shares times 3286 is the 8170. So we do have a record of payment. Now I know it's easy for this court to say, well, and apparently too easy for the underlying court to say, well, you just, where's all your records? Well, 35 years later, this would have been an easy case had it been presented in some fashion of a timely basis. I'm sure you've all been through this if you've been in private practice, but we would have had tax returns from Mr. Robson. He has none going back that far.
Well, wouldn't you also have a canceled check or wire transfer record or something to indicate that you actually paid the money to him?
Very next thing I'm going to say. Okay, and I want to say the tax returns, he didn't have them, and the IRS didn't have them. We requested them from the IRS. They only keep them, I think, like 7 or 8 years. Canceled checks would have made this simple. There would have been lots of bank records. It was his bank was, from his memory, says his bank at that time was Old Phoenix. They're not even in existence anymore. And I think you can see where I'm going with this. Our canceled checks, we do not have canceled checks going back that far. We attempted to get them from the bank, and they do not keep them going back that far.
What about the lost certificate affidavit? Wouldn't you have a copy of that?
Well, yes, and that I wanted to come back to that.
Hang on 1 second before you come back to that. You are just into your rebuttal time right now.
Okay.
You can keep going, but I just want you to be apprised.
Okay, there's a lot here.
I know
I'm
there is.
sorry. But I do want to answer your questions. His paper file, Mr. Robson's, is missing. We have no idea when it went missing or how it went missing. But Mr. Robson had total, complete knowledge of what was involved. And I got to get to my most important point, and that is that this case should have been decided and should have been rejected on the basis of latches. This case would have been an easy case to show who was right and who was wrong and whether he was paid or not. We believe that if there's any presumptions in favoring the validity of his shares, those were easily at least rebutted by the evidence that we showed in several different documents, which are the official documents of Discount Drug Mart, showing that he was no longer a shareholder on our records, that he had not been a shareholder according to our records, and we did actually, luckily, be able to find a record that was 30-something years old that actually makes a listing of us paying him. Canceled checks, all of that would have been really easy, if this was somewhere in the range of reasonableness that he came forward. And he knew he had these certificates. He knew, if you read our brief, he knew that he was required to redeem them when he left. There was a legend on the back of the stock certificates that he had that said these are subject to a stock redemption agreement. Now what happened, and yeah, in a perfect world, we would have had his paper file, but it's not there. But we did. I believe that we were able to rebut that presumption, and I do not think that he presented sufficient evidence to show that he did not get paid for his stock certificates. So the case is really about him trying to collect twice on his stock certificates is basically it. And this is a classic case, and I know you see it, but it doesn't get applied very often. But this is a case of latches if there ever was one in the books. And we did not know that he was claiming to be a shareholder. We satisfied, and it's all laid out in the brief, we clearly in the record satisfied every one of the requirements on latches. The lower court spent not very much time discussing latches except for rebutting, I guess, the various elements. But That's really where this case ends up. Because, and that's the reason why there is latches, is because they're proof, the people are gone. He submitted this 6 months after Mr. Boujay, the founder, owner, last living person that could have actually had firsthand knowledge of what happened with him and with Mr. Robson. So latches has a place in the law, and this is a classic spot where it does apply. Thank you. I probably have about 30 seconds left on my rebuttal.
No, you have over a minute.
Okay, great, thanks.
Good morning. May it please the court, I'm Ted Lesiak. I'm representing Kyle Robson, the appellee in this case. And I'd like to, we did file a motion to dismiss with regard to jurisdiction in this case for lack of final appealable order. I'd like to address Judge Teodosio's concerns regarding that particular issue. In this case, there were 7 causes of action. The court bifurcated the declaratory judgment action. And the question that was asked was there an issue with regard to dividends? I believe Judge Callahan asked that question. Paragraph 53 states, Robson desires a judicial determination of his rights and duties, a declaration as to his ownership rights in DDM, and rights to dividends flowing therefrom. In this particular case, we filed saying that this court does not have jurisdiction over this appeal. Basically, for that the rights and duties of Discount Drug Mart to Mr. Robson with regard to ownership of these shares was never declared by the court. And obviously the other 6 causes of action which would further declare those rights and duties were not determined, and therefore this is not a final appealable order. There was a case cited in that particular matter in the briefs, Puritas Metal Products, which the court found that there was not a finding of rights and duties with regard to someone who was declared not to be a shareholder. This is kind of the opposite situation, where Mr. Robson was declared to be a shareholder in DDM. When I say DDM, I mean Discount Drug Mart. And however, this is not an issue of what rights and duties Discount Drug Mart actually has, but what does it mean when Mr. Robson is declared to be a shareholder? The court has yet to make those determinations, and therefore I believe that this particular appeal is premature and it should be dismissed. Now, addressing the merits of the appeal itself, the standard of review here is abuse of discretion, obviously, because this went to a magistrate and the court adopted the magistrate's decision, which means that the court's finding has to be unreasonable, arbitrary, or unconscionable in its judgment. In this case, you heard specifics with regard to the redemption of these shares, or alleged redemption of these shares back in the 80s. Well, the law is such that these shares could not have been redeemed as a matter of law, specifically.
Okay, can I just ask you a question?
Yes.
Because I'm not sure if there's semantics there or not. You said they could not have been redeemed as a matter of law.
As a matter of law.
Could they have been redeemed?
Well, basically, there's 3 different laws here that would be required in order to properly redeem these shares from Mr. Robson. No evidence was presented that met any of those standards. So basically what we're talking about here is there's a presumption, because there is no dispute that Mr. Robson has the shares in his hands. He still does. The dispute is whether or not these were redeemed. Now, in order to properly redeem shares, there has to be a stock redemption agreement. DDM could not produce such an agreement. With regard to the facts, Mr. Robson does deny, or basically cannot recall that he ever executed such an agreement. And as I said, it could not be produced. Even if it could, the agreement itself has to set forth the terms for redemption by corporation of their own stock under Revised Code 170123. Without an agreement, we have no such terms. In addition, what was presented was quote-unquote extrinsic evidence of a redemption. We're talking about the document that was presented at trial, and also the record will show that there is a dispute that amount that was on that document was proper. However, regardless, any evidence other than the agreement itself setting forth the terms of redemption is not permitted. So that evidence, if there is any evidence that DDM paid for this stock back in the 80s, is not evidence that's good evidence for the court.
I know the court struck a number of documents. Did it accept Exhibit G?
I believe it did. It did. The documents that were not admitted into evidence were basically documents of stock redemption agreements with other employees.
Did you object to
Yes.
Exhibit G?
Yes, we did. We did.
I don't want to take you off your argument, but it seems like this circles right to appellant's argument that this is precisely what latches is for. Because legally, you need particular documents, not the extrinsic evidence, if I follow your argument.
Yes.
Those documents weren't available, weren't introduced, or isn't that what latches is for? That's his response.
Well, with regard to that, we're talking about a corporation here. Mr. Robson was holding shares in a corporation for a long time. Mr. Robson did not have any idea that Discount Drug Mart would claim that he was not a shareholder until his previous attorney requested from Discount Drug Mart information regarding his ownership of the shares. At that time, he was advised that Discount Drug Mart did not consider him a shareholder. And that was 2015, not 1984.
Did any of those stock redemption agreements that had been on for the other employees, did any of them require the employee to give the certificates back to DDM?
I believe probably they all did. I'm not, Your Honor, I can't really say as I stand here without looking at the document itself, as they were not admitted into evidence. So I'm not really sure exactly what they said, but I believe that they did. And I believe that there was some evidence that that was procedure. However, that's also one of the issues with regard to as a matter of law. In order to properly redeem stock certificates under Ohio law, the owner has to take the stock certificate from the person holding. That never happened.
So is your argument then that it's latches on DDM's part as well, that they didn't ask for the certificates back in 35 years?
Well, of course. And basically what it comes down to, latches goes down to the delay of asserting a right. As I stated, Mr. Robson did not delay because he always believed he was a shareholder in DDM. Absence of excuse for a delay, obviously, once again, Mr. Robson believed he was a shareholder. Knowledge that the delay would cause injury. As I said, Discount Drug Mart's a corporation. They have a duty by law to maintain records properly. If they did not, the injury is self-inflicted rather than caused by Mr. Robson in any way. And the last one, which is what we're talking about, what's the prejudice to Discount Drug Mart by Mr. Robson basically sending a letter saying, what is the significance of me holding these shares? What are they worth? Where are my dividends? That type of thing. There's no prejudice to Discount Drug Mart, even if you look at it from a 30-year perspective. Because Discount Drug Mart, if Discount Drug Mart cannot claim prejudice because Mr. Robson is not the one who inflicted any prejudice. Discount Drug Mart, as you heard several arguments up here previously, stated that, well, we couldn't really properly make a determination as to what was paid, when it was paid. We didn't have a file, we didn't have this record, we didn't have that record. Discount Drug Mart is under a duty by law to maintain records as a corporation in the state of Ohio. And that's not for a period of 2 years, 5 years, 7 years, it's forever. And Discount Drug Mart was a corporation for many years before the 80s. If Discount Drug Mart doesn't have records to properly, quote unquote, rebut Mr. Robson's claim as a shareholder, which he's presumed to be as he's holding the shares, the prejudice is due to the acts of Discount Drug Mart, if there is prejudice. But like I said, there was no delay. If you start there, there was no delay in asserting a right. And as you can also see from our brief, we believe that Discount Drug Mart has waived that issue other than plain error on appeal. As I stated, there's also a issue with regard to the matter of law, the redemption. With regard to whether or not there was a redemption as a matter of law, transfer of certificated security, which this is what he holds. It occurs at the time he or a person designated by him acquires possession of the security. Mr. Robson is holding that security. No one ever took it from him. If he is still holding that security, he is a shareholder under Ohio law. As a result, we're requesting that this court dismiss this appeal for lack of final appealable order and lack of jurisdiction, or in the alternative, affirm the judgment of the trial court. Thank you very much.
All right, thank you.
See how much I can cram into a minute.
Minute and 12 seconds.
Oh, 12 seconds, I'll do that. Go. Okay, first of all, they keep saying, we have no records. We presented the best records that we can have. We presented the official stockholder ledgers in several different forms, including showing back where, and if you go through the exhibits, you'll see all these, showing that he's currently not listed as a shareholder. And as far back as we could find the ledgers, we went back to 2003, and he wasn't listed as a shareholder in 2003. We clearly showed and clearly rebutted that possibility. And his claims that he had these shares and that he didn't know, when they were presented by his first attorney, and this is all in the record, said that he believes, Mr. Robson believes, that he had a redemption agreement and that he signed one, but that he did not have a copy of it. And as it turned out, we did not either. But the stock redemption agreement is irrelevant. 1 minute already?
Passed.
Oh.
You want to do a wind-up sentence? Go ahead.
Okay.
Sentence.
This will be a long sentence.
Sentence. He being Mr. Robson, is not being candid, let's put it this way. He says he didn't know. He never received anything from anybody at Discount Drug Mart in 30 years. No financial records, no nothing. And for 30 years. And he's a businessman. I mean, he may not be the Wolf of Wall Street, but he was a businessman his entire career in real estate and other things. Okay.
And
period.
They're all in our brief. Thanks.
Gentlemen, thank you both very much for your argument. We'll take this matter under advisement, issue a written decision in due course. This court will next be having